the moment it is over, it can be filed into court also. So by 30 days, the exchange of arguments will be also over, and the court will be in a position to know what is the real question in dispute and what is the stand of the plaintiff and what is the stand of the defendant. And if only any clarification is required, then only the court can ask the particular advocate to argue. So now 30 days and 30 days and 30 more days we can give. So then the judgment can be pronounced in 14 days. So within 4 months or maximum 6 months, a original suit can be disposed of. For that, the cooperation of the advocates is very much necessary. That is very, very important. They may not think that by disposing of the case early, they may lose some financial interest or that. So what I am submitting is, here, this process adopted in the trial courts would help the expeditious disposal of the trial of the original side cases. And same, when the appeal is filed in the first appellate court, on the first date of hearing itself, it must be made clear that they must file the argument, memorandum of arguments, exchange them, just like in the lower court, and furnish it to the court, and the matter can be posted within 30 days or another adjournment, 2 months, the appeals can be disposed of. Then at the second appellate stage, unless there is substantial question of law, it will not be, and more arguments need not be made. So, like that, a civil suit can be disposed of, because I'm completing the thought regarding the procedure. Because this is not covered by anybody, and my friend concentrated on tribunals. I'm only putting it. And only two other aspects I'll have to. Then, number of the appointment of the judges. The vacancies arise, but the vacancies will be there, and the matters will be posted before the assistant judge, and it will be adjourned. And it will go on for the appointments at the lowest stage. It is taking years together, and even in the appellate stage, and also vacancies in the high courts, they are not filled up immediately. For one thing is, they must filled up immediately after on the day and the vacancy arises, because the administrators will know when this vacancy is arising, what is the date of birth and when he is going to retire. In advance, they can select and put the people who are selected as additional and post them where there is heavy pendency. Like that. And also by increasing the strength of the judges, the process can be speeded up, and this is the there are some other aspects also I have mentioned in my working paper, and there are other aspects on which the concentration will have to be made regarding only the items I'll mention and leave there, because it is getting time. The items which I am mentioning, they are relating to the speeding up, that is mentioned as items. Yes, one is negotiation at the threshold itself. That is also necessary even before the case is taken up. That is one suggestion. Then convening of pre-trial and statement to timely adequate number of courts. So by adopting such these methods, the hearing of the cases can be speeded up, and it will be an effective alternative for the tribunals.
Yeah.
Thank you for
Thank you very much, and I think my friend P P Rao would have been very happy, because this is mostly connected with the increasing the efficiency of the judicial justice administration. But anyway, useful.
Sir, I'll allude only one minute. Yes, yesterday, when the my Lord Chief Justice is here, the Attorney General was mentioning about the appointment. The appointments must be of efficient advocates. And the appointment in the Supreme Court, the two efficient advocates, it would help the administration to Lord, and rather than the promotions in a routine way, it must be done very often, is my view also. Thank you.
Thank you. Before I request Mr. Amit Kapoor to come, just to complete the sequence, you know, immediately after the 42nd amendment, what happened, if you want to know, there was a 43rd amendment brought about in 1978, 79, yes. The same members of parliament who voted for the amendment readily agreed to reverse almost all of them, except, this is what Mr. Shanti Bhushan, then law minister, told in the open court, so I can repeat it to you. Except some of them said that why don't you just retain this 323A and B, let it be there, they are after all harmless. So as a compromise, he agreed to retain it, otherwise the entire, even 326 was reversed and everything else was reversed. And about the service tribunals, how the matters are finally disposed of is generally by the death or retirement of the petitioner. Because if he dies, no LRs can be brought in these proceedings because the service is individual. You can't say that, look, my son will be looking after the service hereafter. And then, of course, retirement is retirement, so they can't come back. They will only be entitled to the pension, whatever it is. That's how it is. And in DRT, death doesn't solve the problem. But in the meanwhile, the property which has been either mortgaged or something is completely gone. And therefore, everybody is happy and comes back. Now I request Mr. Amit Kapoor, who has considerable experience in working in tribunals like the electricity tribunal, etc. And his one of the qualifications which he did not want to mention was that for about 2 days he was my junior.
Mr. Chairman, my senior colleagues, friends, it's a pleasure to be here today. The topic, as Krishnan and Mr. Rao said, evokes significant emotions in different stages of judiciary and lawyers. Those who were there since 50s have a different perspective, 76 had a different angle. People who come last 5 or 10 years have a different approach to it. And I would quote Francis Fukuyama. He's one of the leading thinkers of the 21st century on political institutions, nations, governance. And he said, modern political institutions are complex and they are context specific. They are influenced by contingencies that they have to deal with and overcome. Please look at tribunalization as nothing outside the administration of justice. It actually is an attempt to try and declog, as Supreme Court and the Law Commission said time and again, the arteries of dispensation of justice. And I would draw straight away from Lord Chief Justice's address yesterday. If you recall, he gave us 5 key points on legal reforms. 4 of them, one way or the other, dealt with tribunalization. I'll quote those 4. He recommended that we should all look at multidisciplinary practice. He said that the specialized fields which are coming makes lawyering of the traditional sense a little redundant. We need to evolve as a profession, as judges, as lawyers. He quoted medical negligence, where he said doctors and lawyers must work together. He's talked about gas pricing, where he said economists must be collaborated with. He talks about patent law, where he said scientists must be consulted. He talked about retrospective taxation, where he said accountants must be involved. The bottom line of the message was, we live in the real world. Solutions are found in the real world. And the real world, like it or not, when we are outside our black robes, When we deal with the fruit vendor, the milk supplier, the vehicle manufacturer, we deal with various facets. There is economics, there is finance, there is technology. When you choose your laptop or your phone, or you choose to install a particular air conditioner versus the other, you have to dabble with it, like it or not. So when you deal with a problem in real world, whether it's a citizen, it's a corporate citizen, it's a bank, financial institution, anybody, the solution has to be a real world tangible solution. Like it or not, in our democratic setup, the burden of the final decision, where there's a dispute, there's a choice, there's a right asserted and denied, falls on the Supreme Court and the judges in various courts in the hierarchy. Tribunalization is a facet of that solution. It's a facet of the solution where I quote Justice Hegde in his judgment of 2002, which lent a lot of strength to the kind of expert tribunals we've seen grow. He said, I mean no disrespect to judges of the High Court and Supreme Court, but I do admit that we are not qualified and competent to deal with the complex issues of finance, economics, technology, administration, project management besides law. And therefore, we commend that as the first instance, and as the first appellate instance from there, we must have multidisciplinary expert bodies. And there lies the rub. So if you look at the history of how tribunals have evolved, and if you look at the fact that the Lord Chief Justice mentioned over 30 million cases which are in pendency, the axiomatic story of 20 years, 25 years of life cycle of disputes, the surprising decisions of cases pending since 1960s and 70s being dealt with today, you will realize that tribunalization has taken place in various facets. Would it surprise you to know that the first such tribunal in the modern era was the ITAT, 1941? There are facets which are in service law, they are in administrative law, they affect the consumer, the environment, and then of course there is finance and the hardcore infrastructure. The Supreme Court in the 2010 judgment, where Justice Ravindran, the Constitution Bench, Madras Bar, clearly laid out the Rubicon or the test for us, where you are transferring the jurisdiction of a court to a tribunal. Inherently, it is judicial unless there is a very special reason to have expertise which is outside legal framework. They went on to recognize that notwithstanding, and this was also endorsed in the Namit Sharma case where the whole question was about the CIC, the Central Information Commission, where in review, the initial judgment where directive was issued to appoint a judge as the chairman was reversed, saying that you should have judges chair or participate in the tribunal as per the law made by the parliament. And the test was where you adjudicate, there must be a judicial member. Now that was the directive, and the advice was that the courts and the parliaments must and the government must consider appointing judicial members on the bench. So the question that we must address ourselves to, I don't think it's a question of whether we need tribunals or not. Question is, when do tribunals become a burden which frustrate the three basic tests of tribunalization? The tribunals came long ago. It's been over 100 years in UK. They have been around the world, France, Germany, USA, Canada, Australia. You can go around the world and see tribunals exist, where if you went to the Appellate Tribunal for Electricity, for example, you will find a retired Chief Justice of a High Court sitting in classic judge's robes with a gentleman who's a technical member sitting in his suit with a tie. That's the jugalbandi that tribunals bring. So the test was speedy justice, affordable justice, expert adjudication to enhance the quality of justice. So ultimately, please remember, the same principle of rule law, the theme of the conference today, is sought to be reinforced. And that's where we must test whether tribunals are doing their job. Do they need to be rectified? Do they need to be substituted? Do they need to be scrapped? Now, that's not about throwing them out wholesale. That's about where you don't need to have them, you please take them out. Where you need to substitute retired bureaucrats where this has become a sinecure for having won the favors of the government and getting a long appointment, please substitute them. Where you need those experts, please have them. But either ways, independence of that institution and its functioning is at the heart of the matter. Would it surprise you to know that tribunals like the Electricity Tribunal, under the Electricity Act, statutorily have requirements where the regulator must decide all tariff matters 120 days. Largely now, over the last 2 years, they are deciding at 150. Appeal comes to the Appellate Tribunal for Electricity in 45. condonation is granted from time to time, but largely insisted on. The tribunal is required to decide cases in 180 days. 85%, 90% of all cases filed are decided in 180 days. And therefore, within the second year, you are in Supreme Court if there's a substantial question of law. And the track has been that by and large, from the regulator to Supreme Court, adjudication has taken all of 4 years. These are matters of great significance, the value is high. The involvement for the country, for the economy, in terms of a plant going down, shutting down, its viability, disputes, is of critical importance for development. If you are able to substitute an expert body to step in for a high court, which used to be the appellate body from the regulator, as was the case in West Bengal when Justice Hegde wrote the judgment, does it answer the question? I think with respect it does. But do I say that all the tribunals like the Income Tax Appellate Tribunal, the SESTAT, which have had challenges, don't need to remedy themselves? Are we saying that the non-appointment of members to the tribunals is also something to be given away? No. I think the point is to consider, are they advancing the ends of justice, or is there quality of justice of the nature that it warrants the High Court to keep stepping in and Supreme Court to keep stepping in and interfering? Where they are doing their job largely, they must be strengthened. Where they are not, they must be rectified and corrected. And that is where you will find most of the judgments over the last 10 odd years in this sphere have evolved that thinking. I'd just recommend you to consider judgments like Justice Ravindran's judgment, the Namit Sharma judgment of 2013, the recent judgment Tanjedko, which is April 2014. Each time, and there are 3 constitutional benches since 1950 which have considered the constitutional validity of these tribunals, endorsed them wholeheartedly. So I don't think the consideration is today whether we need tribunals or not. The point of the discussion and the topic is, are they serving the purpose of declogging, or are they bringing another tier which comes back to the High Court and the Supreme Court to create problems? So that's where we must focus our attention. And I would, of course, I will be happy to share the research and send it to the Bar Association. It can be shared with our members to see for themselves. But the important point to note, there are 4 Law Commission reports in India. 1998, 167 reports looked at the GATT, the ITAT and the CGAT, examined the situation across the world in 5 countries particularly, pointed out the flaws of competence, objectivity, composition and approach, a judicial approach, recognized that the need was for speed, expertise and cost reduction, and followed through the 126 report on PSUs where they say we need alternatives to the High Court and the civil courts to decide quickly. Because if you don't decide quickly, one example, what often our court processes are not able to handle, partly because of us taking time and delaying things, partly because of there not being enough appointments, partly because of the complex cases that come, and the burden on the judiciary, is that there is a time value for money. All economies function on 3 basic factors: capital, labor, and resources. Last 5 odd years, the country has seen enough judgments from the Supreme Court. You look at the 2G, you look at the Colgate, you look at the other judgments, all of them have greatly concerned themselves with the natural resources and allocation and utilization. The principle has been to maximize it for the public. In that context, these tribunals, if they function effectively, as some of them do, can reduce that burden and the time frame. I'll just leave an anecdotal reality. The HON'BLE, when that case came up and the judgment and the dispute led to a situation for 5 years they mothballed the project, only 5 years. Because of the dispute, the project was shut down. Over 10,000 crores have been totally written off. That issue of time value for money, that capital erodes as it does not work, is something which we need to carry back in our minds as lawyers, as judges, because that is also at the heart of Article 39. Capital is foundational to any economic growth in the country. If somebody is found at fault, please punish him. But please do not lock down the asset. That asset is a public asset. It has been created in infrastructure, particularly for the welfare of the economy, must be used to the maximum possible for the welfare of the economy. If the person who invested the capital is at fault, please punish him. Please ensure that he and everybody else who is responsible is brought to the book and made example of. But for God's sake, don't cut your nose to spite your face. And in that respect, tribunals perhaps can give an answer which will take the issue away, because when you get a technology specialist in a patent case, you get an expert of a particular science. Let's say there's a nuclear disaster. It's going to be a huge difficulty for judges to resolve the issue and find out who is responsible and where. One classic case, all of us work in the law of contract on sale of goods principles. If you don't supply under the contract to me, I have a right to buy from somebody else and get you to pay for it. Unfortunately, electricity can't be stored. So when a judge tries to, or a lawyer tries to apply the principle of sale of goods, there can't be a lien, there can't be a retention, and there can't be a sale at a later date elsewhere. I can't direct the electrons to come from me and go to Mr. Rao because the grid functions on laws of physics. Now for a judge or a lawyer who's not exposed to it to understand and try and grapple with it is going to be a function of a few months and years. And as a consequence, you have another dabol coming. So I would, with utmost respect, suggest tribunals are needed where expertise is needed. Tribunals are also needed where adjudication is needed, but the staffing of the tribunal must follow the principle horses for courses. If it's an adjudication, you must have a judicial member. And that must be enforced strictly. The courts have stood up for it. The government must wake up to the reality. But where it is expertise, please don't belittle it, but make sure that this is not a sinecure for bureaucrats who were happily on the right side of the government, had nothing to do with the sector. Let the experts come and resolve the problem. They are no worse than anybody else in the country. Thank you very much.
Thanks. There is still a few minutes left, and if I close it before that, you will mistake that we don't have enough material, because the one of the principles of bankers say that there must be a bad debt a little bit, otherwise you are not advanced to the optimum level. So there is few minutes left. Is there anybody has got any questions, please? Yes, Datta.
So the theme of this conference, as we all know, is next level reforms.
Yes.
I think the thing which has been in my mind since yesterday after hearing the Chief Justice was, he did tell us that 65,000 cases were pending in Supreme Court, 30 million cases all over the country. But he did not tell us for how long and how many judicial officers and judges have not been appointed in the courts. We would like to ask him this. I think we should send him a message and he should tell us this aspect of the matter.
Anyway, I have no authority to represent.
He is our Chief Justice. He is the head of the institution.
Yeah.
He will give us the best information.
Yes.
Now the question is, the question that I really want to ask is, and how I put it is, that these national tribunals, of course, Mr. Venugopal and Amit have said, they are very essential. Of course, they are very essential. They are progressing very well also. I am all for them. But I also think that they have become something like the national nursery for rehabilitation.